So I will go ahead and begin. My name is Kim Le. I am an immigration attorney and currently the pro bono and training counsel for SOAR Immigration Legal Services. And I'm joined today by Cole Anabit. We are presenting on immigration pathways for Ukrainian nationals. Cole, if you want to talk a little bit about yourself and your office.
Sure. As Kim said, my name's Cole Anabit. I'm an attorney at Portland Immigration Law. We're a private law firm. I think we're one of the few law firms in the area, at least, that provides services in Russian. So far, we don't provide services in Ukrainian, but I do handle these issues fairly frequently, and so I'm hopeful that I can provide a little bit of information to supplement what Kim's going to tell you today.
Excellent. So first, I'm going to go through and review the agenda for today. So these are the things that we will cover. And that way you understand if something isn't covered quite yet, you'll know whether it's coming later. We will get through all of the slides first, and then we will answer questions at the end. So first, we will discuss understanding types of immigration status. From citizenship, green card status, parolee status, etc. We will also discuss the chronology, the timeline of DHS's response to Ukraine. To be clear, whenever you see an abbreviation, DHS, it stands for the Department of Homeland Security. We will discuss removal proceedings, figuring out to know if you are in removal proceedings, which is another way of saying, are you in immigration court? Or are you being processed outside of immigration court? We will discuss temporary protected status, so TPS. We will discuss family-based options for those of you who have family members who may be U.S. citizens or green card holders. And finally, we will discuss asylum. Based on the numbers, it looks like we don't have many new attendees, so I'm going to keep moving on. And if I see those numbers increase drastically, then we can take a pause and remind folks how to get onto either the Ukrainian or Russian channel. So first, I'd like to talk to you a little bit about the organization I represent, SOAR Immigration Legal Services. We provide immigration-related legal representation and education to low-income refugees and immigrants in Oregon and Washington. We've done this since 1992. Our program is, or SOAR Immigration Legal Services is a program of Ecumenical Ministries of Oregon. We have many staff members here to assist, and our staff members speak a variety of different languages, including Russian and Ukrainian. On the right side, you will see a list of the attorneys and accredited representatives in our office. Accredited representatives are individuals who do not have a law license, but are authorized by the Department of Justice to provide immigration advice and services. We also have support staff and educational staff. The first topic I will discuss is immigration statuses. This explains to you, or what this will cover is the many different types of status that people have here in the United States. First of all, we have folks who are U.S. citizens. Those folks are allowed to stay here permanently, and many of them were born in the U.S., but that is not the only way to obtain U.S. citizenship. If you are not born in the United States or you did not receive citizenship through your parents, then generally you need to have a green card, which is lawful permanent resident status, before you can become a citizen. Now, many of you may ask, well, how can I become a lawful permanent resident? Well, for many of you, that journey begins with a different type of status. So it's really important to understand your own immigration status. So I will start first with folks who are here without inspection. If you entered and did not receive parole status or a visitor visa, If you just crossed the border without anybody seeing you, we consider your entry entered without inspection or undocumented. Then there are folks who had status at some point, but did not maintain their status. And these folks we usually refer to as somebody who has overstayed. Undocumented individual and overstays are folks who generally are more at risk because they have either never been granted status or they no longer have status because they have failed to maintain status. The next group of people have temporary status. So these are individuals with visas, perhaps visitors, students, or employees. This group of people have a temporary time period, have a temporary amount of time to be here in the United States. And the Department of Homeland Security usually tells you exactly how long you can stay. We have folks here on temporary protected status, which is a program designed to allow folks from certain countries that have been designated as TPS countries to stay on a temporary basis. We have parolees, individuals who have been granted permission to enter the United States for a short period of time, based usually on humanitarian circumstances. Again, folks here with temporary status have permission to be here, but for a limited time. Then there are folks who are allowed to be in the United States, are not citizens, and get to be here for an indefinite period of time. These individuals are, for example, include asylees, folks who have been, who have asked for protection from their own home country and are allowed to stay indefinitely. We have folks who have applied for and received lawful permanent resident. So you will see throughout the slides abbreviations that say LPR, that stands for lawful permanent resident. And it's also another way of saying a green card holder. And then of course, as I mentioned early on, citizens who of course can stay here for as long as they want. All right, so the next slide, I will discuss immigration relief for Ukrainians over time. So as many of you know, in February of 2022, Ukrainians began receiving humanitarian parole and or we saw in some instances, visitor visas to enter the United States. Because the invasion of Ukraine happened rather suddenly, there was quite a bit of difference in how individuals who presented themselves at the border were processed. Generally, though, most people were granted periods of authorized stay for a year or less. In April of 2022, the Department of Homeland Security designates Ukraine for temporary protected status. The designation is good for 18 months, and again, is only available for Ukrainians who entered on or before April 11th of 2022. Later on, also in April of 2022, the U4U program is announced and implemented, which then formally created a parole process that would then give individuals 2 years of parole status. In March of 2023, this year, the Department of Homeland Security announced that they were automatically extending parole for individuals who arrived between February 24th of 2022 and April 25th of 2022. Again, this was the time period where individuals were coming in and there was variation in how individuals coming in were being processed. So in efforts to kind of get everybody back on the same track, they have this extension of parole process. First, I'd like to discuss parole. And in order to really delve in, I'd like to start off by discussing some things that we hear from the community about parole, and then we'll talk about whether or not these statements are true. So first, Parole gives me temporary permission to enter or remain in the United States. My parole will automatically be renewed. After a year, I will automatically receive a green card or lawful permanent resident status. And after 5 years in the United States, I will qualify to apply for US citizenship. As you can see here, only the first statement is true. Parole gives me temporary permission to enter or remain in the United States. The second issue, your parole will automatically be renewed, will depend. Again, it's that time period. If you entered between February and April, and the dates again on the previous slide, those folks should receive automatic parole. But we don't know about anybody who entered after April, whether those individuals' parole status will be renewed. There has been no announcement yet. So at this point, we hope that everyone will be automatically renewed, but they may or may not. The last two statements, however, are not true. And it's unfortunate, but many people in the community have been told not to worry, after a year, you'll receive a green card, or after 5 years, you can apply for citizenship. This is not true. The reason why many people are confused about about being able to apply for citizenship after 5 years is because there is a general rule that if you've had lawful permanent resident status for 5 years, you can apply for citizenship, okay? Generally, if you have had lawful permanent resident status for 5 years or more, you can apply for citizenship. And there are a few exceptions, et cetera, for that. But that's perhaps the root of this myth. But no, just because you are here on parole status does not mean you automatically qualify for citizenship after 5 years. So let's delve into parole and what it does mean. You are allowed to enter and stay in the United States until the date that's listed on your I-94. The I-94 document is something that can be generated and is usually found online. I'll show you a photo of it in a little bit. Prior to the U4U program being implemented, again, most folks received parole for 1 year, but subsequent to the U4U program, individuals received parole for 2 years. If you receive parole, this is not a travel permit so that you can just come in and out of the United States at your will. In fact, you are advised generally not to try to travel, because parole is a program where you're telling immigration, I need to be let in for my safety. So if you are traveling left and right, then the US may reconsider whether or not you actually need to be paroled into the United States. Parolees also may apply for work authorization. So when can a parolee begin working? Ukrainians who are paroled into the country are employment authorized incident to parole status. This means as soon as you enter on parole status, you can start working. However, you still have to provide an employment authorization document, abbreviated as EAD, within 90 days of your hire. So we strongly advise individuals to apply for a work permit as soon as possible after entering the United States. You can file for your EAD, your work permit, online at USCIS's website, and here's the web link is on this slide. The application fee for a work permit through parole is usually $410. However, initial applicants have that fee waived. A C-11 work permit is generally valid for only the duration of your parole. And I say generally just because sometimes we see odd documents, but usually you are allowed to work until the expiration date of your parole. And the C-11, when you see us throughout the presentation refer to C-11 or C-9 or C-8, these are categories of work permits. So someone who has a work permit that says C-11 on there means that this individual received it through parole, as the basis in which they were granted the work permit was parole. Application processing times may vary, but we've been seeing these work permits come back very quickly. Now I'm going to review the automatic parole renewal process for individuals who entered on parole between February 24th, 2022 and April 25th of 2022. If you entered during that time period, you were most likely granted only 1 year of parole. The Department of Homeland Security announced that they would automatically be extending these parole for these individuals, and you can go online at this website, so i94.cbp.dhs.gov, in order to find, basically, they've uploaded a new I-94 for you. If you look online and you've entered in your passport information, etc., and you don't see an updated I-94 that gives you a longer period of time here in the US, then you can submit an inquiry by using this website, help.cbp.gov. You're going to select traveler compliance, select then another drop-down menu that says Ukrainians paroled, US Russia invasion, and you will let them know, enter in the information to basically request that they update that the I-94. What we've been told is about 5 days or so after that, you would log back into the I-94 page and it should be updated. Those who have already filed for employment authorization before will also receive an extension of their work authorization. So they'll receive a new form I-797C. This form basically is a notice form from immigration letting the applicant know that they are now work authorized for an extended period of time. Those notices will be mailed out to the address on file. So it's important that you keep your address updated with immigration. Again, it's for those who have already filed for employment authorization. So if you did not file for employment authorization when you first received parole, but your parole is now extended and you want to apply for employment authorization, you still can do so. If you qualify for an automatic employment authorization, but have not received your extension notice, you can send an email to this address, which is on the slide. I'm going to show you some of the screenshots, the pages on how you request your I-94 to check and see if your current stay or your current parole has been extended. So this is the website that I had listed in the previous slide, this I-94cbp.dhs.gov website. From that page, you will go ahead and click on this button that says Get Most Recent I-94. And the image on the right side is what the I-94 looks like. It's basically a very short one-page document usually, and it tells you when you are admitted until. So right here it says admit until date, and of course this is a sample one, but you'll see on here it says October 10th, 2012. So that's how you would check to see whether your parole status has been automatically extended. This is the information that you would enter in to obtain the I-94. So they will ask for your first, your last name, birth date. Document number is usually your passport. So you'd enter in your passport number, which is usually on the top right-hand corner of your passport. And then you would select Ukraine for country of citizenship and click next. Next, Cole will cover removal proceedings and understanding whether you're in removable proceedings and what to do if you are in removal proceedings. Cole, I have given you control.
Hey everyone, thank you, Kim. That was great. So just before I get started talking about the specifics of removal proceedings, I just want to set a baseline understanding. Removal proceedings are essentially what most people consider deportation. That is, the government is forcing you to leave the country. And not everyone who is listening to this call is in removal proceedings, but if you are, it's very important that you know the steps of that process. And so that's what I'm going to try to give you more information about today. So here, these are some common perceptions, and some are true and some are false about removal proceedings. So some things that I hear frequently in my practice that I'd like to discuss today are whether the government can deport you immediately and without notice. Some folks who come into my office, maybe they have a status like parole, maybe they don't have any status, but they're very worried that the government can just come, knock on their door, pick them up, and deport them without notice or remove them. Some folks are wondering whether the government is going to provide an interpreter when they go to court for their removal proceedings. Other folks want to know whether the government will provide an attorney because they've probably seen in television, on movies, or in the US Constitution, and learned about the right to counsel in courts in the United States. And then other folks want to know whether the government is going to reschedule their hearing if they're unable to attend, or how to reschedule a hearing if they can't attend. Oops. Okay, there we go. So whether the government can deport you immediately and without notice, no. So once you're here in the country, the government has to go through a process, and it's usually quite a lengthy process if they want to deport you from the country. And that process is removal proceedings. And we'll talk about how the government starts removal proceedings against someone and what that looks like documentarily. But generally speaking, they cannot just come knock on your door, arrest you, and put you on a plane and send you somewhere. The government will provide an interpreter during removal proceedings, and they'll provide an interpreter in your preferred language. The government often makes some presumptions about what your preferred language is based on your country of citizenship or nationality. If they've set an interpreter for you in removal proceedings in a language that is not your best language, you should tell them that, no, this is not my best language. I speak this other language, and then they need to provide you an interpreter in that language. The government will not provide an attorney in immigration court. So immigration is considered an administrative process, not a criminal process. And so the current state of the law is that the government does not have to provide you with an attorney. This means that although you have a right to an attorney, if you want an attorney, it's going to be an attorney either you hire yourself by paying or from one of the programs available like Equity Corps or SOAR that can sometimes provide representation in removal proceedings. And then whether the government will reschedule your hearing if you're unable to attend, maybe. If you can get in writing a reschedule notice, then it's safe to assume that your case has been rescheduled. If you do not have something in writing, you should not assume that your case has been rescheduled. You must attend any scheduled hearings until you get a paper saying otherwise. Okay, so the first question when trying to figure out whether you're in removal proceedings or in deportation process is, did you receive a notice to appear? The government uses a notice to appear to begin their immigration court case against you. And that means they're trying to deport you. All of the information on that notice is very important, and then you should receive this notice and review it carefully, ideally before you go to court the first time. So we'll look at what one of those looks like. Okay, so this is a sample notice to appear, and this is what they generally look like. There are some differences sometimes, but kind of the most important information on this document is going to be present on other notices to appear, even if they don't look exactly the same. So let's look at some specific parts of this. Here at the top, you can see the document's title, notice to appear. That's how you know it's a notice to appear. Then you can see the name of the respondent. So the respondent is the person responding to the charges that the government is bringing. That is the person that the government's trying to deport. So if you're the one in removal proceedings, this should be your name. If your name is misspelled, that's something you definitely want to bring up with the court. Likewise, if your contact information is incorrect, it's very important that you tell the government about this, because they're going to send future correspondence. Okay. They're going to send future correspondence to that address. And if it's the wrong address, you're not going to receive that correspondence. Something that I see really frequently, unfortunately, is somebody moves when they're in removal proceedings. They tell ICE, because they're doing ICE check-ins, that they've moved. And ICE says, okay, we're going to update your address. But they don't tell the court. And then the court changes the date of their first hearing, sends a letter to the old address, and those folks never receive that letter, and then they miss their hearing, and then the judge, in their absence, orders them removed or deported. You have to change your address with both ICE and EOIR, that's the Executive Office of Immigration Review, or the Immigration Court. You have to change your address with both of those agencies, so you do not miss any correspondence from either of them. Okay, so this is the body of the notice to appear, and it has a few pieces of information that the government is trying to get from you. This explains why they're trying to deport you. And usually it's because you came to the United States without a visa, but it could also be that you came on a visa and you've overstayed. What you want to check is which of these boxes at the top is checked. And depending on which box is checked, removal proceedings can be slightly different, or the deportation process can be slightly different. The allegations, these numbers here, those are going to tell you why the government thinks they have a legal basis to deport you. So in this case, they're saying this person is not a citizen or a national of the United States. They're saying that the person is a native of Kyrgyzstan and a citizen of Kyrgyzstan. They're saying that the person entered the United States at or near San Luis, Arizona on or about September 29th, 2022. And they're saying that the person was not then admitted or paroled after inspection. So what I see fairly commonly these days on notices to appear is number 4 here, not then admitted or paroled, applied to some folks who were actually paroled into the country. So that's something to keep an eye out for. If you're looking at your notice to appear and you know that you got parole when you were released by the government at the border, but they're saying you weren't paroled, that's something to maybe bring up with the judge, or ideally with an attorney before you go to court the first time. And then down here at the bottom, it says which law or regulation the government is using to remove you. And that's going to be different depending on that box checked at the top, and could be different depending on the numbers here in the middle portion. At the bottom of the notice to appear is possibly the most important piece of information initially, and that's where and when you're going to go to court. This tells you when the government expects you to physically go to an immigration court and appear. Now, the government's supposed to give you your first date and time and where you go on your notice to appear. What happens frequently, though, is they put a date on here, they send it, they file it with the court, and then the court says that there's no availability that date. And so they change it to a different date, and then they send a new hearing notice. And that goes back to what I was talking about before, where if you haven't updated your address with the court, they might send that notice to your old address, and you'll think, oh, I'm going to court March 15th. But really, you were supposed to have gone to court in January. And you go on March 15th and the clerk says, oh, you don't have court today. You were here in January, or you're supposed to be here in January, you weren't, so the government told the judge that the judge should remove you, and the judge ordered your deportation or removal back in January. In that case, you have to do what's called a motion to reopen. It's a whole process. So you really must update your address with the court if you move, even if you have a notice to appear that has a date and time on it, because that might not be the date and time that the court ends up wanting you to be there for the first time. Okay, so the notice to appear means the government is trying to deport you. We've gone over that. So what can you do? The best thing to do is to get as much information about your particular situation as possible. Now, getting information about a case can be confusing. There's lots of misinformation available on the internet. You might have friends or family that have been in removal proceedings in a similar but not the same situation, and they're telling you one thing and you're reading another thing. The best thing to do is to meet with an attorney. I know, just practically though, that can be hard. Attorneys cost money, and some of them don't have time to see folks for months. If you need information, just basic information about what's going on in your case, you should call this automated number. And there, at least, you're going to figure out whether you're in the system or not, and if you're in the system, when your next hearing date is. So that number is here on the screen. When you meet with an attorney, it's a good idea to have a list of questions that you want to ask that attorney before you go. Some things you could ask an attorney about are whether prosecutorial discretion is available in your case. Prosecutorial discretion could be a whole presentation in itself, but generally that's some of the choices that the government's attorney has in how they want to proceed with your case. Maybe they don't actually think it's important to deport you, or maybe they think you shouldn't be deported at all. And so an attorney could get in contact with them about that before your hearing. You could ask an attorney whether you'd be eligible for temporary protected status. You could ask an attorney whether you'd be eligible for adjustment of status or applying for a green card, which Kim touched on earlier. Ask an attorney about asylum. If you're from a place and you're afraid to go back to that place, even if other people have told you like, oh, you don't have a case because you don't have documents or you don't have pictures or whatever, if you're afraid of going back to the place you're from, you should definitely talk to an attorney about an asylum case. And then there are many other forms of relief that might be available to you that an attorney who's familiar with these types of cases can help you identify. I hope I'm not speaking too quickly. Okay, so how to check if you're in removal proceedings. There was that number that was on the previous slide. Call that number. Sometimes the number's not working correctly. Sometimes it's inconvenient to call the number. Yes, I will speak slower. Sorry about that. You can also check online. So in my experience, this service works pretty well. A lot of times it has outages, and it seems to work best on Chrome. So just a few tips. This system allows you to access your case information if you have your alien registration number, also known as an A number or a USCIS number. You can find your alien registration number in a few places. You can find it on a notice to appear. Here it's actually edited out, so that's not super helpful. Let me go back a few slides where the notice to appear was available. I should have set that up better. Okay, here we go. So here's the notice to appear, and this is the A number. Here it's called a file number. It's your alien file number, essentially with your immigration case. With all of the government's immigration related agencies, you're going to have this same number. And some of them are going to call it an A number, a file number, an alien number, a USCIS number. It's typically 8 or 9 digits. And this is where it's located on your notice to appear in the upper right-hand corner. So moving back to our current slide. Okay, so this here is your card number. That is not your A number. This is the A number here, USCIS number. On this sample, it's 000000725. It would never be that. It would be, 08 something or other, or 212 something or other, 8 or 9 digits. And that's what you're going to enter into this dialog prompt here, where it says enter your A number at this web address. What that's going to do is provide your current case information from the Executive Office of Immigration Review, or the Immigration Court.
All right, and then I will go ahead and talk about temporary protected status. So whether or not you are in removal proceedings, you may be eligible for temporary protected status. Again, temporary protected status is when the Secretary of Homeland Security, so the Department of Homeland Security, designates a foreign country for temporary protected status if the conditions in that country temporarily prevents the country's nationals from returning safely. At most, each designation can be good for 18 months. However, a country's TPS status can be extended and/or the country can be redesignated. What is the difference between an extension and a redesignation? If it's extended, it means that anybody who registered the first time that it was the first round that country was designated as TPS eligible, those folks can continue to renew their TPS status. But anybody who did not enter before the TPS date, so in this case, April 11th of 2022, those folks cannot apply for TPS. If Ukraine is redesignated, so that would be different than an extension, but if Ukraine is redesignated and the Secretary of Homeland Security says, we now redesignate Ukraine, anybody who entered before, I'm giving you an example, but June 29th, 2023 can apply, that would be a redesignation because it basically resets and it opens up so that more people can apply for TPS. That hasn't happened yet. Currently, anybody who arrived and has lived in the United States before April 11th of 2022 and is from Ukraine, those individuals are allowed to apply for temporary protected status. To apply for temporary protected status, you must prove and show that you are a national of the country that was designated for TPS. This usually means you show that you have a passport there. You must file during the registration period. So within the time period that immigration says they're going to accept applications for TPS, and you must prove that you have continuously and physically lived here. So usually copies of your lease or copies of employment records, etc. You also cannot have been convicted of any felony or 2 or more misdemeanors in the United States. There are also a number of other crimes that you can't commit or you may be ineligible for TPS. For the current round of TPS, you must file by October 19, 2023. This means that immigration must receive your application before October 19th of 2023. To apply for TPS, there's an initial filing fee, of $50, and there's a biometrics fee, $85. If you want to apply for a work permit for TPS, it's $410. You do not have to apply for a TPS work permit you can apply for just TPS status with no work permit. So that is an optional application that you can file with TPS. And again, you must prove continuous residence since April 11th of 2022. On this left side, you'll see just a little bit of the first page of the I-821, which is the form that you use to apply for TPS. I meet with many clients who say, Kim, I already have parole status, I already have TPS, but I don't like that TPS only extends for 18 months at a time. I don't like that there's an end date on my parole. What can I do to stay in the United States permanently? What can I do to get a green card? There are several ways to apply for permanent or indefinite status in the United States, but one of the most common routes is family-based options. If you have a family member that's a US citizen or green card holder, then we would often ask, who is that relative that has US citizenship or green card status? So I'm going to cover first family-based options for relatives of citizens. First, if your spouse or child, and when I say child, I mean someone who is unmarried and under the age of 21, okay? So if your spouse or your child is a US citizen, you may be able to apply for a green card immediately. Your spouse, who's the US citizen, must be 18 years old or older, and or the child must be 21 years old or older. So if you came into the United States in May of 2022, and you've just given birth to a child this year, that child is not yet 21 and cannot file a family-based immigration petition for you yet. What if you say, Kim, my parent is a US citizen? If you are less than 21 years old, then your parent can file a petition for you and you could apply for a green card immediately. If you are 21 years old or older and your parent is a US citizen, your parent still can petition for you, but you will need to wait longer before a visa is available to you. If your question is, well, Kim, how much longer? I will have to say it depends. Right now, it's more than 8 years. It takes a long time, but we don't know for sure because every month, immigration tells us who they are who they are granting visas or who they are granting green cards to, who have previously filed I-130 or family petitions based on having a parent who is a US citizen and where the relationship is a parent and the child is over 21 years old. So we don't know, these announcements we call the visa bulletin comes out every month. But if you're under 21 and your parent is a US citizen, then you will most likely be able to apply for a green card immediately. What if your brother or sister is a US citizen? Then your sibling, brother or sister, may petition for you, but you will need to wait for a visa to be available, much like the previous relationship I described. Right now, generally, we would say it's probably at least 13, 14 years for a sibling petition to be approved. So these are long waits. If your parent is a lawful permanent resident and you are less than 21 years old, oh, I apologize, this needs to be updated. You can apply for a green card, but it's no longer immediately. As I mentioned earlier, that visa bulletin changes every month. And recently the visa bulletin was updated and pushed back. So now there's a wait. If you are a green card holder and you're applying for a child under 21 years old, there is a wait now. And right now, we're guessing about a year or two, but we don't know for sure. If you're 21 years old or older, then your parent can petition for you if you are unmarried, but you will still need to wait for a visa to be available. This is really important because if your only relative in the United States is a parent who is a lawful permanent resident, then you need to know that choosing to marry may make you ineligible for a petition filed by your parent. However, if you are married to a US citizen, for example, you may no longer be eligible for a petition filed for you by your lawful permanent resident parent, but you may now be eligible for a petition filed by your US citizen spouse. So I'm going to take a moment to say there is no limit. You don't have to pick between family members who can petition for you. If you have a brother who's a citizen and can petition for you, your brother can file a petition for you. If you have a mother who is a lawful permanent resident and you are not married yet, that mother can also petition for you. You don't have to pick just one family member to petition for you. However, each family member who petitions for you will need to file his or her own application. What if your spouse is a lawful permanent resident? Again, this category retrogressed, which means it moved backwards. And so I apologize, I need to update this for you, but there is a wait currently, but you can apply for a status, you will just need to wait. Again, that spouse must be 18 years old or older. Some quick updates about, or some quick tips on family petitions. Again, more than one family member can petition for the same beneficiary, for the same immigrant who's trying to come. Generally, family petitions are automatically terminated upon the death of a petitioner. So if your parent files a petition for you and your parent dies, that petition generally is terminates. There are exceptions, especially if the beneficiary is already in the United States. However, this is really an important to remember because it might make sense to have multiple family members petition for you. So this is something to discuss with an immigration attorney. Approved family petitions do not grant lawful status. So beneficiaries will still need to apply for a green card or for an immigrant visa after. So just because your spouse filed an I-130 family petition for you does not mean that you have lawful status. Being a beneficiary of a family petition does not negatively affect your ability to obtain parole or TPS or asylum. So don't feel like you have to pick between filing a family petition and keeping your TPS status. Right, Cole.
Okay, so I'm going to talk a little bit about asylum. I mentioned asylum earlier as something to discuss with an attorney if you're afraid to return to your country of citizenship or nationality. And what asylum is essentially is protection, and it protects you, the applicant, from persecution. Now, what constitutes or makes persecution is a big subject, but I like to approach this thinking about it as, are you afraid of returning to your country because of who you are? And specifically who you are in your race, in your religion, in your nationality, in your political opinions, in your sexual orientation, or your membership in another particular group. What is a particular group? That's a huge question that I'm not sure anybody really knows the answer to, but any sort of group that is bigger than who you are yourself, that includes other people, that could be a particular group. It's something you want to talk to a lawyer about. When you're thinking about asylum or thinking about whether it's worth pursuing asylum in the United States, you should know some realities about the process, and that's what I'm hoping to provide today. So with a few exceptions, applications for asylum must be filed within 1 year of your entry into the United States. So if I enter the United States today, and we're at June 29th, 2023, that means I have until June 29th, 2024, usually, to file my asylum application. Now, a judge can tell you to file your application earlier, and if a judge tells you to file your application earlier, you need to do it by the date the judge sets. But generally, speaking from the law, from the statute, you have 1 year from your date of entry. Okay, so what does asylum get you? Individuals granted asylum can live in the United States indefinitely. That means with no set end date. Now, Kim mentioned this earlier when she was talking about forms of status. Asylum is one form of status in the United States. Asylees can also apply to adjust their status, that is, become green card holders or permanent residents. Asylees are limited somewhat in how they travel outside the United States. So an asylee should not travel outside the United States without talking to an immigration lawyer first, and should definitely not travel to their country of nationality or citizenship from which they sought asylum in the United States. When you are an asylee, when you travel outside the United States, you're not supposed to use your passport. You're supposed to use a travel document that you get from the US government. It's best to discuss that with an attorney well in advance of any international travel plans. So how do you apply for asylum? We're going to give a very general overview of the process today. Each step in the process is very important, and this is something you really want to get advice from a professional on. So you can file for asylum by submitting Form I-589. If you are not in removal proceedings, you can probably file your I-589 online, and I would recommend doing that. It's generally a more user-friendly process than trying to file it in paper, although they did just update the paper filing process to make that quite a bit more simple too. Filing online can be done through the USCIS website, and they have a little tool when you go to online filing that's going to help you decide whether you're eligible to file online. Definitely read those steps very carefully if you're completing this on your own, because it's going to tell you whether you're actually eligible to file online or whether you have to submit a paper application with USCIS or a paper application to the immigration court. If you are in immigration court proceedings, you most likely need to file an application with the immigration court. So one important piece of this to know is there are no application or form fees. You're going to find some sites online, if you're looking for information about the asylum process, that tell you you need to pay to download the correct forms. That is false. You do not have to pay for the forms. They are free and available online. Okay, so if you're filing online, you want to create a USCIS account, and they're going to prompt you to go through that process if you're able to do the online filing. If you have to do a paper filing, you're going to download the most recent edition from the USCIS website. A tip, oftentimes when folks click this form, it'll open in your browser. If you open it in your browser and you put the information in your browser, you cannot save your progress, and oftentimes you will lose your progress. You want to make sure you download the form and open it in a PDF editing program like Adobe and edit it there, not in the browser. Okay, so what do you file with your asylum application? Basic pieces of an asylum application are going to be that form that we just talked about, the I-589, and a declaration, proof of identity, proof of your family relationships and your family members' identities, supporting documentation, and country conditions evidence. Okay, so what is all that? The form we've talked about, this is the government form, the official form from USCIS, file online or physical copy. Your declaration is your story. So this is you declaring or telling the government why you feel you have been persecuted or will be persecuted if you have to go back to your home country. It's very important in this declaration that you talk about the specific details of your life. This is not your time to tell the government about general details of what's happening in your country, unless those details specifically relate to what's happening to you or what happened to you in the past. You want to tell the government your story, giving them the important details they would need to understand what happened. So that's who did these things or who would do these things. When did these things happen? Where did they happen? Why do you think they happened? How these things happened? What happened? All of these details, as if you were telling someone a story about your life, should go in your declaration. If you're meeting with an attorney about your asylum application, it's a really good idea to at least make a draft of your declaration, a first try before you meet with that attorney, so that when the attorney asks why you believe you're eligible to apply for asylum, you have that information available. You should include proof of your identity. Now, if you entered the country without a visa, it's very possible that ICE or CBP took your passport when you entered the country. Now, hopefully, they've given you a copy of your passport with a stamp and a signature, which you can use. If you don't have a copy of your passport to submit with your application, you're going to have to provide an alternative form of photo identification. You're going to want to provide proof of your relationship with your family members. So if you have a spouse or minor children that you're including on your application, you're definitely going to want to provide documents like a marriage certificate or birth certificates that show that those relationships with you are legal relationships. You want to provide supporting documents. So if you have photos of what happened to you, if you have medical reports, criminal reports, maybe you filed a police report, maybe you had a lease agreement or property agreement that has something to do with what happened to you. These are important documents to include in your asylum application. Now, I should mention that all of this documentation needs to be either in English or translated and certified by the translator into the English language. That can get expensive and it can be time-consuming. So the most important thing to keep in mind while you're doing this is, can I get all of these documents by my deadline? If you're right at the end of your 1 year here, file what you absolutely need to file, and you can add in documents later. Whether to include a document in your case can be a strategic decision. And so it is a very good idea to at least speak with an immigration attorney about what documents you have prior to filing your asylum application. So the final point here is country conditions evidence. So earlier I mentioned that it's not a good idea to talk about what's generally happening in your country unless it specifically relates to what happened to you in your declaration. And that's true. The place to talk about what's generally happening in your country is in the country conditions evidence. And those can be news articles, reports from international agencies or NGOs. They can be US government reports. This is whatever shows that what happened to you happens generally or happened because of the general situation in your country. And that can be submitted when you file your asylum application, or it can be submitted later in the process. So I spoke a little bit about the declaration earlier. When you write your declaration, focus on what happened to you and focus on details which you have based on your personal experiences. Now, it might be the case that you've studied generally what happened in your country and you have a lot of information about the political situation. Try to focus on the details of the political situation that are specific to your story. Write your declaration in chronological order if you can. It helps when someone is reading your story for them to know what happened first and then what happened second in chronological order. If you put what happened at the end, at the beginning of your declaration, it can be confusing for someone if they're looking at this for the first time. And then, as I mentioned earlier, write who did these things, what did they do, how did they do them, when did they do them, where did this happen, and why do you think they did that to you? In the US asylum process, it's not always about what the truth of what these people thought about you is, but it's more important why they thought the things they thought. So maybe they thought you had certain political beliefs, and so they attacked you for that. Maybe you didn't actually have those political beliefs, and it's not true that what they thought. But the fact that they thought those things and attacked you because of those things is very important to include in your story. For proof of identity, as I mentioned earlier, ideally we would use your passport. Sometimes you don't have your passport, in which case you'll have to look for other forms of identification. We would like to include your I-94, and that you can obtain through this link, but you will use your passport information to get the I-94. So if you don't have your passport and they didn't give you an I-94 when you released from detention or paroled, it can be difficult to get that document sometimes. You'll want to include your birth certificate with a certified translation if it's not in English, and your marriage certificate also with a certified translation if it's not in English. So for proving your family members' identities, you use passports, birth certificates for everyone, and again, certified translations if the document is not in English. Examples of supporting documentation, and I'll highlight this text, and I don't know if that's going to make it more legible or not. I don't think I can do that. Okay. Well, I'll speak extra slowly here so the interpreters can catch it. You would like to include any medical records from treatment you received. If you're telling the judge or the officer in your story that you went to the hospital after someone attacked you, expect the judge or the officer to ask if there are medical records relating to that hospital visit. Sometimes it's the case that you didn't bring those medical records or they didn't give you any. And that's an okay answer if that's the truth of what happened. But expect the question. If you tell the judge or the officer that you filed a police report, expect the judge or officer to ask you for a copy of that police report. If a copy is unavailable or they didn't give you a copy, or you were afraid to ask for a copy because of who the police are, that is an answer to the question, but again, expect the question. If you tell the government that you received threatening text messages or calls expect them to ask for records of those calls or those messages. I hear very often folks tell me, oh, I was getting text messages or calls. And then when I ask them for copies of those, they say, oh, I got rid of that phone. I don't have them anymore. That might be the answer, but you'll really want to provide details about why you got rid of that phone. Why don't you have these things? Because the government is going to expect, if you received calls or messages, that there is some record from those. Social media posts expressing your political views or your membership in a particular group. Again, just like the messages or the calls, if you're saying you made posts on social media or in a Telegram group, you should go to whatever steps you can without putting yourself or others in danger to get those posts. Telling the government that you deleted all of the posts is perhaps the true answer, but they're going to look very skeptically at that. So if those posts are still there, you should get them and you should provide them. Draft notices. If you were called up to go to war and you opposed the war because of your religion or your political views, and you tell the government you received a draft notice, provide a copy of that draft notice if you can. Employment records. If you were persecuted at work or if you lost your job because of persecution, provide employment records. And then finally, signed letters or declarations from other people that know what happened to you. If you're relying on the testimony of other individuals who have knowledge of what happened to you, those individuals should provide signed statements and, if possible, include their contact information and a copy of their photo ID. That photo ID ideally would be their international passport, not their local ID. Otherwise, you're going to have to pay to get that translated and certified as well. Country conditions evidence. Earlier, I mentioned a couple times that you're not talking about the general situation in your declaration. You're talking about what happened to you. The general situation should be described through supporting evidence of the country conditions. Here are some examples of what country conditions can be: news articles, academic studies, social media posts. You can read the list. It's any source that isn't you that's telling about what's happening generally in your country. We want to show, ideally, that your situation, while the details of it are unique to you, the type of situation, the type of persecution that happened to you happens to other people in your country. If you are saying that you fear persecution in your country on account of your political views, showing that other individuals with similar political views have been persecuted will help your case. If you're saying you fear persecution on account of your religion, ideally we would be able to find some country conditions evidence demonstrating persecution of other individuals with similar religious views in your country. Where do you file your asylum application? We talked a little bit about this earlier. The main thing I want to impart through this presentation is that if you are not in removal or deportation proceedings, you should file with USCIS. If you are in removal or deportation proceedings, you should file with the Immigration Court. Now, there is often a situation where someone was detained at the border and then they were released, and on their notice to appear that we reviewed earlier, they were given a date and time to go to court, but then when they check that phone number or they check the online system, their case is not in the system yet. If that happens, you cannot file with the court because the government hasn't filed your notice to appear with the court to start the process. In that situation, you would need to file with USCIS because your case is not pending with the court. Later, USCIS may transfer your case to the court, or the court may decide, because your case is pending with USCIS, by the time the government files your case, they're just going to end your case or dismiss it, terminate your case. That's a special situation. If you're in that situation, definitely talk with a lawyer if you can. Okay, so where to file? If you're filing a paper form, you want to mail it to the right place. They've updated some of the filing addresses recently, so definitely double check. Don't just use what's on this presentation. Go to the USCIS website, get the most current version of the form, and file it at the address that's currently on the USCIS website. Okay, when can I get a work permit? If you're filing for asylum, the government has the responsibility to adjudicate or make a decision in your case in 5 months or 150 days. That almost never happens. So if they don't do that, they're supposed to give you employment authorization or a work permit. You can apply for a work permit based on your pending asylum application, usually once your case has been pending for 150 days or more. The category for that application is C8. So on the form I-765, as Kim mentioned earlier with parole, that category is C11. For asylum, it's C8. So it's important to apply with the correct category. Here, I just provide an example. If you filed your asylum application March 22nd of 2023, the first day you could file your work permit application is 150 days later. That is August 19th, 2022. You can file form I-765 without a filing fee for your first asylum-based employment authorization document. You can have a parole work permit and an asylum work permit. And there are lots of people who have parole who have applied for asylum, and they have a C11 work permit and a C8 work permit. Okay, actually, I want to just, sorry, Kim, I want to mention one more thing about that. If you filed your asylum application online, you should probably file your work authorization application for your asylum-based EAD or employment authorization document online. So if you applied for asylum online, probably file your employment authorization online. Just anecdotally, or in my experience, those are processed much faster for folks who previously filed their asylum application online, like in a matter of days sometimes, as opposed to months. So it is a big difference if you filed online. Okay, thanks. And so I'm going to move on to Kim.
Sure. So this is some of our this is our contact information, our telephone address of our Portland office. We also have an office in Hillsborough. That's our email and our website. We do offer consultations, and we strongly encourage you to schedule a consultation with an experienced immigration attorney if you are thinking about applying for any of the above benefits. Even if you very clearly qualify for a benefit, you may not know that you also qualify for another benefit. So it's really important to speak with somebody to assess your situation. Also, if you're planning on applying for asylum and can't find an attorney or can't find assistance, it may be helpful to just at least meet with an attorney to discuss the types of evidence that you plan to include, so that we can give you the most updated information. As you can see in this presentation, there were things that have been updated since we last presented in March. So immigration law changes frequently, so it's really important to be connected to either a nonprofit or an immigration attorney that can advise you.